All rise. All persons that have business before the honorable associate judges and are presiding over the district of the Court of Appeals, draw your hands and give your attention. God save the United States and its honorable court. This honorable court is now in session. Please be seated and come forward.
Good morning and welcome to the District of Columbia Court of Appeals. We have one case on our calendar this morning. It is 20 AA 759, ALICIA ECKENRODE versus the District of Columbia Police and Firefighters Retirement and Relief Board. Counsel, when you're ready, you can come to the podium and let us know how much time you would like for argument and how much time you would like to reserve for rebuttal.
Good morning, Your Honors. May it please the court. My name is Paul Fenn. I'd like to reserve 3 minutes at this time. I represent petitioner Alicia ECKENRODE, who is also with me in the courtroom today. This is an appeal taken from the decision of the DC Police and Firefighters Retirement and Relief Board regarding a request for an enhanced survivor annuity. This court asked counsel to brief the issue and to address primarily the issue regarding jurisdiction of this court based upon whether or not my client had a right to a trial type hearing before the board regarding her request for an enhanced survivor annuity. As an initial matter, it is now undisputed in this case that my client had a legitimate statutory and protected property interest in an enhanced survivor benefit. And you can see the board's brief at page 6, where it admits that this protected right exists. However, the court must then look at, as we have briefed, what are called the Matthews 3 factors regarding this issue to determine what due process was required below. First is the petitioner's interest in an enhanced survivor benefit is substantial. Here, what we're talking about is the difference between 100% and 40% of the total amount that was paid, that was the salary of Sergeant ECKENRODE, to be paid to my client, plus a $50,000 lump sum amount. In the statutory scheme that's set up in the district, the only persons that can apply for such an enhanced survivor benefit are persons that can demonstrate that the income provided by the passing officer here, Sergeant ECKENRODE, was greater than 50% of the income of the person applying, usually either a widower, or a family member. That in and of itself demonstrates the significant nature, and I think the legislative intent regarding the substantial nature of my client's interest in receiving and getting a full trial type hearing below. It already sets forth therein, and looking under the 2 cases that we have cited of Goldberg and Powell, Goldberg related to welfare benefits, Powell relating to housing subsidies. Both were focused on income, the need for income and the deprivation of that income, and more importantly, the impact of that deprivation of income upon the applicant for the subject benefit. Here it's written into the statute. The only persons that can apply for it are a limited class of people. And that limited class is defined as people that are receiving more than 50% of their income from the individual officer who was killed in the line of duty. That is highlighted in the applicable statute 5-716A2. The board's decision to summarily deny the enhanced annuity benefits to Mrs. ECKENRODE without any sort of hearing has left her literally with over half of her income gone that herself and her 3 minor children depended upon. This is a limited class of persons that can apply for such an enhanced survivor benefit, which applies to the 3rd factor that I will get to. The board, in response to the 1st factor, which is the nature of the privacy interest that I'm addressing right now, primarily relies upon Richard Milburn, the case of Richard Milburn. And there the court acknowledged that even a significant interest may not be protectable by a trial type hearing. However, in that type of case, it related to a public school charter. That public school charter and the public school charter's compliance in order to keep its charter, that compliance is written. That is, they had certain statutory, certain written procedures that they had to follow to keep their charter. Therefore, the court's analysis really relied upon what I would consider a thin required analysis required below, meaning below, they really were just looking at, did the charter school comply with written requirements to maintain its charter? There was no need for any sort of factually intensive analysis.
I just want to make sure I understand. Are you saying, I was sort of expecting you to say that the nature of a chartered school and its charter is different from the nature of your client's interest in kind of money she might and need to live and support her family. But it sounds like you're saying something different, which is shifting over more towards the nature of the determination.
It is. I'm on my way to the shift to the second factor. However, yes, I absolutely agree with you. There is no sort of analysis done in that case related to, and certainly a charter school's charter does not relate to money income coming to an individual to survive, to pay for medical, housing, food, and those types of things. Therefore, I don't think it has any application whatsoever.
Can I ask you another case that I believe is cited by your opponent is a case of ours called Jones, which involves a police officer's administrative sick leave. And in Jones, we did say that there were certain constitutional procedural due process rights that would be accorded to the officer. But we had previously said, and we didn't cast any doubt on in Jones, that that wasn't a contested case, so there wasn't full trial type proceedings. And in Jones itself, we said, as part of explaining why there were certain procedural due process rights that were entitled, though not full trial type rights, we said that Officer Jones, the administrative sick leave in that case, it was undisputed, was the sole means of the officer's support. So I'm wondering how, with respect to kind of the significance of the interest, how you factor Jones into your argument.
I think with respect to Jones, Jones gives primarily it lays out the analysis certainly that we're here about today. But what we're talking about in that case, you're right. It was the officer's sole potential source of income during a period in question, and that was sufficient to mandate some protection, the court found, and that protection was less than a full-blown hearing. However, what we're talking about here is very different. We're talking about a survivor of a killed officer on duty. Therefore, you're dealing with somebody going through emotions that I hope none of us ever have to go through. Two, you're dealing with someone that was dependent upon another person's income. As a result, had made plans and led a family of 3 minor children, still minor children, in certain ways, purchased certain things, done certain things. In the particular case of Jones, we're talking about an individual disability benefits that they were to get. The difference there is the individual disability, it may be their sole source of income. However, it's noted in several cases, they can go out and get different other types of support. And they're not going through any sort of the same sort of situation as we are talking about here. And more importantly, I go back to what I just spoke of before, the statute itself. The statute itself limits this, and I think the legislative intent is clear. It limits such an enhanced survivor benefit to persons who are deprived of more than 50% of the income they're relying upon. Therefore, within that intent, I believe it distinguishes it from Jones.
I want to make sure I take your point that sort of needs limitation supports a conclusion that as a class, the people who are seeking this kind of relief are more likely to, be living more hand to mouth, and it's more like Goldberg versus Kelly. So I get that line of thought. But when you just refer to legislative intent, I get a little unsure about doctrinally why you think that's relevant to the procedural due process question that we're trying to sort out.
Well, to respond to that, I think it's different for the reasons that I've stated, but also in Jones, the first element that I was just covering in Jones, the court found the potential deprivation in this case, because it's permanent, is thus of a different and in a sense weightier nature. It then went on to the risk of the erroneous deprivation, the second and third factor, I think, to really find that there was no need for the trial type hearing. I think the first issue with respect to the full deprivation did lean in favor or weigh in favor of what we're requesting, which would be a full trial type hearing below.
And if you're shifting then to that second topic, before we shift to the second topic, do you agree with the following, which is that under our case law, even where there's a protected interest, and some procedural due process protections pre-determination are constitutionally required, that it's ordinarily not full trial type. There's kind of the general rule is no, and you need to show sort of extraordinary or special circumstances in order to suggest that not only is some pre-ruling process required, but full trial type pre-ruling process is required.
I don't know, Your Honor, respectfully, if I'd go so far as to say that you'd have to show an extraordinary circumstance, but I do think you have to show a distinguishing circumstance. And I do agree with your comment that generally the answer is no. You don't get a trial type hearing below. However, with respect to the second factor, the informal and unilateral procedures employed by the board in this action, those already highlight the tremendous inherent risk of the current board procedures, which is distinguished from Jones that we were just talking about. Because what we have in this case, and in the statute actually says my client had a right to appear before the board. There's not even a distinction whether it's a hearing, there are no procedures in writing. What does that exactly mean? And what did my client have a right to do in her capacity as an appellant? However, what
Can I ask you just because I want to make sure I understand why you think what you're saying is relevant to the analysis. So I get your point that the procedures that Farrell said folks like your client are entitled to by statute and regulation are pretty minimal. And to the extent your point is there with the Constitution entitles somebody to more. I'm not sure that's going to lead to a favorable answer to the jurisdictional question, unless the answer is not only are you entitled to more in various ways, but you're entitled all the way, not just to, here's what you get. The Constitution is here. You need to say the Constitution, for us to have jurisdiction, you need to say the Constitution entitles your client to a pre-ruling trial type proceeding. And so kind of attacking as inadequate in a variety of respects, the procedures currently provided by the board under statute and regulation to your client.
Mm-hmm.
I'm not sure I'm not saying it's irrelevant, but it seems like it's going to fall short of what you would need to do. Do you
I
agree with that?
agree.
What are the procedures that would be required in your view, given the kind of showing that has to be made by your client to reduce for there to be an acceptable, I suppose, risk of erroneous deprivation?
Trial type hearing, evidentiary hearing.
An evidentiary hearing, meaning that you can present witnesses
Absolutely.
under oath
Absolutely.
and subject to an ability to cross-examine
Yes, Your Honor.
the evidence presented by the board.
Yes, Your Honor. And my point in describing the inherently flawed procedures that are in place is to highlight the fact that what we need here is a trial type hearing because of the type of case we're talking about. We're talking about a situation where we have at least two medical opinions that are at play. We have a medical examiner and we have another doctor from the PFC. They gave an opinion in this case. One, our doctor from the PFC said, line of duty injury caused death. Summarizing. The autopsy in of itself said natural death and gave no description of what that meant, and therefore described the cause of death as pulmonary deep vein thrombosis. The issue there is you've got medical opinions, some of which, at least the medical examiners, are extremely vague. So what in fact had to happen here and what demonstrates the need for a full trial type hearing here is the board found it vague by the fact that they reached out to the doctor, the medical examiner, to ask the medical examiner, what did the medical examiner mean? By doing that, they inherently had a one-way conversation with the examiner, not recorded. My client couldn't cross-examine. We still don't know what was actually said by the medical examiner because there was no recording of it. But what comes into play here is credibility and factually intensive analysis in these types of cases. It's the same thing if I'm before the Superior Court in a motor vehicle accident and I have medical experts. We don't just hand the reports up to the judge or the jury and say, this is reliable because it's a doctor and it's really just factual and that's all they have to say. Credibility is on the line. Veracity of those reports is on the line. All elements that play into a trial type hearing are on the line in this type of case. And when you look at the third factor, when you look at what exactly Matthews requires, the administrative costs and burden analysis here, we've already got the board already has a mechanism set up for trial type hearings for members and non-members with disability.
Do we know, for example, of the relative numbers in terms of how many retiree proceedings there are that require hearings?
Retiree wise, no.
As opposed to survivors who would come under this classification of seeking enhanced survivor benefits.
I do not have numbers, Your Honor, but what I can tell you is this: if we were talking about a significant number of survivors that were applying for enhanced survivor benefits, that would be all over the news, because that would mean officers are dying in the line of duty all the time. And that there are survivors that had over 50% of their income being provided by those particular deceased officers. I submit to you, I don't know the numbers exactly. It cannot be very large in terms of annual hearings that would be held in cases like this, which is all we're asking for. We're not asking for every single applicant for a survivor benefit to get a full trial type hearing. It's the applicants for an enhanced survivor benefit where they are dependent upon more than 50% the income of that particular officer.
And they can make that showing of sole and direct result.
Correct,
Right,
and
which
that's
is a separate issue. But I wanted to ask you about that. I understand that one of the requirements to make such a claim is the over 50% dependent on the deceased officer. But then there's also this question which starts to get into the merits. But what I want to know is, to what extent does it, quote, relate back or link to the jurisdictional question and the need for certain procedures?
it
Again,
really,
pre-termination,
I'm sorry.
given the I'll call it a strict interpretation of the statutory language by the board.
It relates very strongly. And that is because in order to analyze appropriately, what does sole and direct mean? And is it complied with by the person applying for the benefit? Is it shown? The only way you can go through and show sole and direct, or if you want to say proximate, or however you want to say the word direct, the only way you can show those types of things is through an evidentiary hearing. You cannot make that determination, whether as a judge, a jury, a board, an administrative agency. You could never make that determination based upon two conflicting, which I don't believe they're really conflicting in this case, but two conflicting medical opinions. You could never make that. You would need to know, what did the medical person, the doctor here, medical examiner, what did he or she examine? What did he or she determine played into their medical conclusion? That's the cross-examination need. That's the need to have the full evidentiary hearing. And that sole and direct standard really amplifies the need for that type of evidentiary hearing.
Can I ask you, how would you explain what seems to be a necessary component of your position, which is that a post-determination trial type proceeding to challenge the correctness of the determination would be constitutionally inadequate? Because for you to prevail on the jurisdictional question, it seems to me, you need to be able to establish that before making its determination, the board was required to conduct a trial type hearing. So that's pre-determination trial type proceeding. And the due process clause, or cases say ordinarily you don't have a right to predetermination trial type proceedings. Sometimes post-deprivation proceedings will be adequate. And so it seems as though, so I'm going to put it this way: imagine this is not our regime, but imagine there was a regime that said, the agency, the Metropolitan Police Department will decide about whether to award an annuity of this kind, and it'll consider whether it's, death is in the somewhat odd wording of the statute, the sole and direct result of the injury. And it'll do that, based on the information that it has, just like lots of times agencies decide things, but then it's not going to have any adjudicatory process at all. And then if somebody doesn't like it, they can go and they can object, and they can have after the determination, they can have a trial type proceeding to challenge the legality of the initial determination. If there were a regime like that and it would be constitutionally adequate, then it seems like we might not have jurisdiction, because the Constitution wouldn't entitle your client to a pre-determination trial type proceeding. So first, do you agree that for you to prevail on the jurisdictional question, you have to show that your client has a constitutional right to a pre-determination trial type hearing?
I do.
And what's your argument about why that trial type right has to be pre-determination here and couldn't instead be relatively promptly post-determination?
Same reason as I think that are set forth in the two cases that we are primarily relied upon, this case of Powell and of Goldberg. And that is because it is a significant, it's more than a significant, it is quite a substantial deprivation of a financial, its income, of a financial asset, I'll call it, that changes the game. And the reason I say it that way is because, again, family of four, family of one, family of two, whatever it may be, you are literally taking the vast majority of their income, in some cases, all of their income, taking it away by a pre-deprivation hearing without a trial right. If the
When you
board
say
were to
taking it away, I'm not sure that's
ruling
right.
that they're not entitled
Right.
to it.
So it's not like it's something they already have that is being withdrawn.
Thank you. Ruling that they are not entitled to get it, because as in this case, Mrs. Eckenrode was getting and is getting 40% of the average amount of salary of her deceased husband from his time on the force. However, what they are doing is they are denying in my view, more than a substantial interest, private interest to her, highlighted by the language of Goldberg and Powell related to income that you cannot get back. Now, if there's a post deprivation here, first, I don't believe we have that here. So there's no sort of safety net that's going to save my client in the sense of getting that full trial type hearing at some point.
Well, I guess that seems to get into very deep water, which nobody has kind of tried to wade into.
Understood.
If the Constitution entitles your client to more fulsome post-deprivation procedures than have so far existed, then I assume your client can obtain them by seeking review in Superior Court and demanding those protections and saying that the Constitution entitles your client to them. So I do think if there's a constitutional right to better process, your client would have a way to demand them and obtain them by way of the process of review in Superior Court.
Potentially, Your Honor, I still think, however, from a pre-deprivation perspective, looking at the Powell and Goldberg cases, both of those cases highlight what we're here about. We're here about a deprivation or a denial of an applied for financial right that significantly impacts the livelihood of a person. Here,
Can I ask you,
a widower.
There's no provision whatsoever in the administrative process for a post deprivation full hearing.
Not to my knowledge, no.
How would you compare the right at interest in this case to the right at interest in some settings that come to mind as analogous, where then one could like look around the country and see what courts have said about constitutional rights to pre-ruling process, like let's say disability of the individual rather than a survivor annuity, or workers' compensation, retirement disability, workers' compensation and the like? Would you say it's pretty comparable, and so the cases that address that question around the country are pretty relevant? Or do you think this case is quite different in ways that mean that the answer to whether there is a constitutional right to pre-decision trial type proceedings in those settings could be quite different from the answer that you think would be appropriate here?
I do think they are different, but I think one of the cases you may be referring to is Matthews, which you've all quoted, because it's the three-step process and analysis that we've asked this court to apply here. Matthews is the disability benefits case. And in Matthews, I would like to quote, and this is from Matthews at 340, 341. It says eligibility for disability benefits, which is what was at issue there, in contrast, and that's in contrast to Goldberg, in contrast, is not based upon financial need. Indeed, it is wholly unrelated to the worker's income or support from many other sources. So again, it's making this distinction between the financial need and the substantial impact of the denial of that financial support to an applicant. It goes on, and I'm now quoting from 341, as Goldberg illustrates, the degree of potential deprivation that may be created by a particular decision is a factor to be considered in assessing the validity of any administrative decision-making process. So again, this case in and of itself, which is a case that the board relies upon appropriately, I think. However, it's very distinguishable, and it highlights for me the distinguishing facts right there, which is, again, it was not discussing the denial of a financial right, a substantial financial right in that case. It was talking about disability benefits that it did not determine was the same.
Now, this case isn't directly, I mean, the statutory factor that relates to, in a way, to the degree of need for this annuity isn't directly need based in the sense of saying, what are the assets of the person seeking the annuity and all that. So it's somewhat, I don't mean loosely in a strong, it's not directly an assessment of need. Can you remind me, it's 50% of support? Is that the word? Is that the statutory word? And so can you tell me exactly how it relates to need? I mean, so if is it taking into account net worth, or is it considering only annual income, or how's it? What are the details, if you know?
I will get that, Your Honor. I'm looking at DC statute 5-716. And it's A2 and A1. A2 says, talks about the member's death was the sole and direct result of personal injury while performing such duty. And then it talks about is survived by a survivor, parent, or sibling. If it is found that that is the case, that they meet the threshold, the evidentiary threshold, it's a lump sum payment of $50,000 that's to be paid. That has not been paid to my client because she was not granted the enhanced survivor benefit. Shall be made to the survivor if the survivor received more than 1/2 of his or her support from such member.
Support.
Support is the word there. Now, Your Honor, admittedly, there's no financial statement, personal financial statement requirement. Nobody submits. My client has to submit, and they're not going to submit personal financial statement. But you're talking about more than 1/2 of, it says his, it should be his or her support for such member. So we're talking about.
I'm sorry to interrupt, but I haven't looked into this.
Sure.
Are there regulations that sort of explain how MPD understands this 50% support requirement that might shed light on kind of at least how what approach they're taking to that topic?
I have not looked into that, given that it just hasn't risen to the top here in this review.
I haven't either, so I was curious.
I have not, Your Honor. There are no other questions. I'll be seated.
Thank you, Mr. Penn.
Thank you.
We'll give you some time in rebuttal, but
Thank
we'll
you.
hear from the government now. Thanks.
Good morning, and may it please the court. Alex Lichtenstein for the Police and Firefighters Retirement and Relief Board. This court lacks jurisdiction to hear this case, and I want to pick up on the discussion you were having with my opposing counsel because I think his example of Powell is actually a good illustration of why this court lacks jurisdiction. Powell is the only case in recent decades where this court has determined that there was a constitutional right to the panoply of trial type procedures necessary to make a case contested. And that case is factually very different than the case we have here. On the personal interest, that case involved the final termination and permanent termination of housing benefits, without which those applicants would not be able to secure housing at all. Here, although there is a needs test in the law, Mrs. Eckenrode and applicants like her do receive a floor of 40% annuity based on their spouse's income from their position. So unlike in Powell and unlike in Goldberg, there is another source of support that Mrs. Eckenrode is receiving.
But if we follow the statute again, we don't know what other assets. Well, I don't know what support means, and maybe you can help with understanding that, but for her to be eligible for this, what she would lose, she would have to show that 100% annuity. She depended on that for more than 50% of her support. right?
That's right.
So
And
it's a significant loss to her.
absolutely, we do not deny that the loss to Mrs. Eckenrode is significant and that it is indeed a major
you
financial
also-
strain.
You were also talking about Powell in terms of saying that it was a permanent determination. And we talked a little bit before about pre-termination determination, right? A pre-eligibility in this case, and a final determination. Can you tell me what would happen after this? If she goes to Superior Court, what does that proceeding look like?
So as I understand it, were she to go to Superior Court, it would apply the same standard of review that this court would in looking for substantial evidence in the record to
So
support
no
the defense.
further opportunity for a trial type hearing. Is
That's
what you're saying?
correct, Your Honor.
And that is based on what? Why do you say that that's all she would get?
That's my understanding of this court's precedents in terms of when agency actions are reviewed in Superior Court or in this court. So it's the same standard of review that is applied.
Do we have to answer that question in order to resolve the jurisdictional issue? Because it seems to me a pretty hard question, whether leave aside whether there's a constitutional right to a full trial type proceeding pre-eligibility decision. But whether what the board affords to survivors seeking annuities is constitutionally adequate otherwise. That seems like a bunch of interesting due process questions. We'd look at cases like Jones and see was this an oral hearing, and there'd be a lot of questions about what all due process would entitle folks to. And I'm not sure what I think the answers to those questions are. But do we have to decide them in order to resolve the question?
You don't, Your Honor, and that question is not before this court. It has not been
And
briefed before this court.
Relatedly, if let's say your opponent is correct that what is provided by statute and regulation to Ms. Eckenrode is constitutionally inadequate, even if there's no right to a predetermination trial type proceeding, it's constitutionally inadequate in other respects. Do you agree that the proper forum to raise those claims would be Superior Court? And so Ms. Eckenrode could say in Superior Court, whatever is normally the case, something I'm very confused about when I'll ask you a question about in a minute, but whatever is normally the case, the Constitution means that what happened already in determining whether I'm entitled to this annuity was inadequate. And I need additional process. Superior Court, you're constitutionally required to give it to me. If she's right on the merits, that the procedural due process clause entitles her to more, then she could get it in Superior Court if she could persuade the Superior Court that was correct. Is that true or not true, you think?
She could certainly raise it in Superior Court. The Superior Court might have questions about why she didn't raise this in the first instance before the board, but she would be certainly free to make those arguments.
I'm sorry, I don't quite understand. Why would she have to raise what process she should get in a post-deprivation hearing before the board in a pre-deprivation posture?
I believe Judge McLeese's question went to the procedures that she would be constitutionally due, not rising to the level of trial type procedures. If I misunderstood that question, I apologize. But
my question was ambiguous, actually, so it's a very good follow-up question by Judge Easterwood. But my question was not so much focused on whether the claim would be that Ms. Eckenrode was entitled to those pre-termination, as to which maybe she could have asked the agency to provide them. And so there might be a procedural preservation issue.
Mm-hmm.
Or a separate question, which would be maybe whether she was entitled to them pre-deprivation or not. She may at some point be entitled to some things, maybe all the way up to trial type proceeding, maybe things short of that. With respect to claims of post-deprivation due process entitlements, you would agree she couldn't have defaulted those or failed to preserve in front of the agency because you weren't at that stage.
sure. And I think that the kind of simple answer to that combined question is that she would be free to raise those claims before the Superior Court.
Do you know of any case where that has occurred?
And
I understand that we're taking you beyond was in the briefs, but it's important.
I'm not familiar off the top of my head with any of those cases, Your Honor. If the court were interested in supplemental briefing on that issue, we would be happy to provide it.
Can I ask you, though, you do say your understanding is that when there's a proceeding in front of an agency that is not a contested case, and therefore the DC APA does not provide jurisdiction for this court to review the matter as a contested case, that the process in Superior Court is APA style review of whatever the agency did. It seems to me that can't always be true. And I actually think we have cases on both sides of that topic, which may depend on context. So, I mean, lots of times agencies do tons of things. And some of them are after adjudicatory type proceedings and some of them are not. And so you're not suggesting that anytime someone goes into Superior Court and challenges the legality of an agency action, we apply APA style deference and administrative review to what the agency did, or are you?
I'm not, Your Honor. My understanding of this court's cases was that the Superior Court would review for substantial evidence, but there could be a line of cases that I'm unfamiliar with that provides for different review based on the facts before the board and the type of adjudication before the board.
Well, again, sometimes agencies don't have anything that's even remotely adjudicatory. And so then you'd have to create a record in front of the Superior Court about what happened.
Right. And that is not the situation that we have.
Well,
here.
what I find confusing is that we're kind of in a midway posture. And so here's my question. So I take it you agree that if an agency hasn't done anything adjudicatory, and it makes a decision, and there's no review in this court because it's not a contested case, and someone goes to Superior Court, what we've said is that you file an equitable action. That's what we said in Farrell about kind of what the option in Superior Court would be. And would you would agree that then that would be like a lawsuit, and you would file a complaint, and you would have discovery, and you would go through summary judgment, and you might end up in a trial. Is that right? That seems like it would have
That's
to be true.
consistent with my understanding.
And then we do have cases for sure that say, for example, in employee cases where there is a full adjudicatory process, it's really a contested case process, but there's an exception in the DC APA that says those go versus Superior Court. Well, in cases like that, it's very clear that the Superior Court is supposed to do APA style review on the record that was created in front of the agency, and then this court reviews sort of de novo as a second layer of kind of APA style review. What I find confusing are cases that are somewhere in the middle, where the agency has done a half-baked adjudicatory process, where it hasn't created, not the kind of process that you might ultimately think would be best designed to get answers to whatever question the agency is deciding. So there's an administrative record, there's an administrative determination, there were some facts provided, but maybe not a full opportunity to develop the facts. And how that's supposed to happen in Superior Court and how the Superior Court is supposed to review agency action, to me, is very unclear from our cases. If you think there's a case that clearly explains that, I myself at least would be very interested in hearing about it. But and this case seems to me like it could be sort of in that middle, because your opponent's argument, not an unreasonable one, is this is a factual issue. It's important. And the process so far has been very half-baked. They're like people calling people on the phone and asking questions about things. And then people, on review, quoting, medical examiner records or handbooks to try to explain what all that means. And it's not like a very ideal process to figure out what the best answer is. And it's just not obvious to me that if Superior Court is the right place to go, it's not obvious to me that the only thing that happens in Superior Court, either constitutionally or as a matter of our law independent of the Constitution, is to just take the record, however it was somewhat incompletely created in front of the agency, and have that be the sole basis for the Superior Court's deferential review. But that's your position. Your position is Ms. ECKENRODE has already had everything she's constitutionally entitled to, and she's statutorily entitled to APA style review of what the agency did. If I understand your substantive position, that's right.
That's correct, Your Honor. And I would say that, in those two types of cases you've identified, this case actually falls far closer to the latter case, where there is a developed record, there is medical evidence in the record. Mrs. ECKENRODE had a variety of procedural protections before the board. The proceedings had to be reduced to writing. The board had to produce a written opinion with findings of fact and conclusions of law. Mrs. Eckenrode had the opportunity to appear in person before the board if she had requested it. She would have also had the opportunity to seek an evidentiary hearing and to be represented by counsel if she had requested those.
She would have been granted an full evidentiary hearing with presenting witnesses under oath, cross-examining the medical examiner, all of that.
Yes, that's not required by statute or regulation, but the board regularly grants those requests when they're made by applicants. And she did not, in this case, request such a hearing. But she did have an opportunity.
On what authority does the board grant that procedure then, if it's not authorized by reg or statute?
I believe it's just an exercise of the board's discretion.
Did they feel like they don't want to do it in a particular case?
My understanding is that that's never happened.
And is there anything that tells claimants that they can ask for all these things, that they're likely to get it?
I'm not certain about the notice that Mrs. Eckenrode receives or that applicants generally receive, but I do know that applicants have made requests, these sorts of requests to the board. So there's some amount of notice that they are given about these rights.
I mean, this is very odd. Right, because if this were in a regulation, this process, whether or not she had requested the hearing, that would make it a contested case proceeding and would give us jurisdiction, right? If this were actually written down somewhere. But now you're saying it's not really written down anywhere. It's just kind of loosey-goosey pattern and practice. Maybe people know about it, maybe they don't.
I think
Maybe they do it sometimes, most of the time, all the time, but it's on the litigant to ask.
I
This
think
makes me more uncomfortable than less.
I think, Your Honor, if the regulation said specifically that the applicant is entitled to a full evidentiary style hearing with the panoply of trial type rights, then that might be a statutory, or I guess it would be a regulatory requirement for a contested case. But if the regulation were written to say that she may have the opportunity for such a hearing on the board's discretion, this court has said that that sort of discretionary granting of a hearing is not enough to create a contested case. And I think that that is the big picture here. We've gotten kind of into the weeds, but the real question before this court on the jurisdictional issue is whether Mrs. Eckenrode had a constitutional entitlement to the full panoply of trial type rights that were required to make this a contested
Right, and I guess
case.
what I'm struggling with is here we have a statute that says, look, there's this special benefit for people who are in need, right? For people who've received more than 1/2 of their support from the member who has died. So that's recognizing that the need is great, right? And then you're telling me that the sort of the practice is that they regularly give hearings for these cases. And those two things seem to recognize that this is really important, and this is exactly the kind of thing that you would need a full-blown hearing for. And I'm wondering how that impacts your argument.
I think two responses to that, Your Honor. The first is that we would disagree somewhat with the characterization of this enhanced annuity as being for those particularly in need. The enhanced annuity was designed as an additional benefit for the very narrow and small set of individuals who are killed in a line of duty as the sole and direct result of the injury that they incurred in the performance of duty. And that's 5-716A makes that clear. The
But
requirement.
that's not enough, right? It's not just that they were killed in the line of duty, it's also that their survivors have this actual need.
That's correct. And there is a needs test in the statute. But what Goldberg says is that the type of extreme personal interest necessary for the full panoply of trial type procedures are the very means by which to live. We have no disagreement that this is a significant interest for Mrs. Eckenrode and others like her. We have no disagreement that individuals might rely on their spouse's income or whatever annuity they receive to support their lifestyle and the manner in which they've become accustomed to live. But there's no evidence to suggest that in the normal course of proceedings, or even here, this enhanced annuity was necessary to provide applicants with the very means by which to live. Things like.
Can I ask you, trying to figure out the answer to the procedural due process question and focusing on the question of need. Is it your view that should be determined kind of on a categorical basis? So let's look at this statute and let's look at the kind of the links it has to concepts of need and try to figure out, generally, does that mean that for most or many people whose rights are implicated by this provision, it will be kind of the means of existence kind of inquiry? Or is it a case specific, or is it some of both? What's the level of generality at which we're supposed to figure out whether there's a constitutional right to a pre-termination hearing? Is it, individual to Ms. ECKENRODE and proof about her situation, or is it class-wide, the people affected by the statute, or both?
This court made clear in Donnelly Associates, citing to Matthews, that this is an inquiry that focuses on the generality of cases. The particular circumstances of an individual's situation do not bear at all on the court's determination.
And is it, you pointed out there's not any direct evidence other than, the statutory terms about exactly how tightly this would go to the means of existence rather than an important financial interest. I take it's your view that the burden was on Ms. ECKENRODE to establish all of that in order to prevail, or would be on her to prevail?
Yes, Your Honor.
And is the way one would try to go about that to try to figure out things like what's the average salary of an MPD officer and what's the average poverty line for cost of living in DC, and figure out the relationship between half of one of those things and the other of those things? Is that the kind of inquiry that you think if someone were trying to spin that out, one would undertake, or how would you do that?
Well, first of all, to answer kind of that question, we actually do have evidence in the record that 40% of the starting salary of MPD officers would be above the poverty line for a family of 3. But in answer to your more general question, the Matthews test is a balancing
That's
test.
in the record in front of the board?
No, Your Honor, that is just.
We just said there was evidence in the record.
I'm sorry. No. The type of evidence in the record that Mrs. ECKENRODE might have produced would go.
Sorry, I want to go back. I just want to make sure I understand exactly what you said. I'm not trying to pin you to the floor or anything. I just want to make sure I understand what's in the record and what you're saying about what's in the record. I thought you had said that there was some information available to us that would say that half of the average salary of a starting MPD officer would be above the poverty line for a family of 3. Is that something that is factually available to us in the record somewhere, or is it or not?
I apologize if I misspoke, Your Honor. It is not in the record before you. The statutory terms are something that you could take judicial notice of. But the actual evidence is not in the record.
But was a determination made here? I just don't remember. I guess not. That she did meet that more than 50% support requirement in the statute? Oh, they never got to that because of the sole and direct result.
That determination is not in the board's opinion.
So looking, for example, at whatever was submitted on this record by Ms. ECKENRODE is not going to be helpful to us.
No.
So we're just completely at sea as to what support means.
Was it contested?
No, Your Honor. It was not raised as far as the proceedings in the record indicate. We do have information from the files.
Is it contested now?
No, Your Honor.
Can I ask you, so when you were back on the procedural due process question, and in particular the nature of the interest here and whether it is more like a Goldberg versus Kelly Powell kind of interest or some other kind of interest, you focused on Powell and explained why, in your view, the interest here is not as sort of fundamental means of living type interest as was the case in Powell. But that doesn't really answer our question, because it doesn't tell you, Powell said you have a right then, and the question is how much less critical can something be and still trigger that not normal but sometimes applicable requirement. And so instead, if you were trying to point us to cases that have comparably significant need-related interests where there have been determinations that they are insufficient to create a constitutional right to pre-decision trial type proceedings, where would you point us?
There are several cases in the record, Your Honor, but I think the closest case is one that we actually didn't cite in our briefing, which is Walters v. National Association of Radiation Survivors. That's 472 US 305, a Supreme Court case. And that case involved an annuity for service-connected death and disability. It involved very similar interests to the one at issue here, with perhaps even more heightened need based on the fact that, you know, these disabled veterans weren't able to support themselves by any other means and were not, as I've mentioned, receiving a 40% annuity. And the Supreme Court there determined that retirees and survivors were not entitled to the right to counsel, which this court has said is an important part of the contested case procedures.
That was the only thing that's determined there about the right to counsel, not about other
It was,
trial type.
Your Honor, it was a specific determination about the right to counsel. But to
Can I just make sure I heard the site correctly?
472 US 305, 1985 case.
Not finding that, so that may be my problem or typo, but I'm not finding it right off. Anyway.
I may have a typo too, Your
Okay.
Honor. But to that question, I think that it's important to understand that the Matthews factors are a balancing test. So it's not that a certain level of personal interest triggers the need for the full panoply of trial type proceedings.
That's a very fair point. But if you go to the other two parts of the balancing, your opponent says with respect to the third, what's the beef for you all? You are up and running on a huge process of creating, giving trial type proceedings to the bulk of the people who appear in front of you. So it's really no big issue for you to accommodate the few who fall into the category of his client. Do you disagree with that analysis?
I do. I think first, Matthews directs us to look at the function of the agency, and here requiring full trial type hearings would undermine the board's function of getting these survivors the enhanced annuities to which they're entitled, simply because it would lengthen the process. It would require hearings to be scheduled, often weeks or months after the application.
Well, generally, though, the board has made the determination for most applicants that the balance between getting things right and getting things done quickly favors providing contested case proceedings. So why is there some special reason why that balance of the relevant considerations is different for folks in this category? So
the legislators have determined that the full panoply of trial type rights are necessary for retirees. If I had to hazard a guess about, and this isn't in the legislative history, but the fact that survivors already receive a 40% annuity as the floor of what they receive, and this is a special enhanced annuity reserved for a small group of people, it is entirely possible that, Congress might have determined that requiring these trial type hearings unfairly tipped the balance towards delay and away from getting those who are clearly entitled to the enhanced annuity, the annuity as quickly as possible.
In terms of the burden on the agency, there is on the one hand, the fact that say retirees generally have these hearing rights, so the board is set up. And I think you have at one point mentioned, right now you mentioned the small class, or you mentioned to the tiny, I think you used the word tiny, number of cases that involved officers who die in the line of duty, right?
Yes. Your
So
Honor.
the additional burden is tiny?
So the number of these sorts of cases that come before the board is much smaller than the number of retiree cases. But we do think that there would still be an additional burden, not just on the board itself, which is a part-time institution, but also on the PFC physicians who would have to come testify, take time away from their patients, and on the medical examiners who would have to take time away from their full-time jobs to come testify. So we do think that there would be some burden, but even if you believe that that burden on the board would be relatively de minimis, that has to be balanced against the fact that those additional procedures add little to no additional value.
Well, that I really want to get into because I'm interested in your views on how valuable or how probative of the kind of the substantive question the board has to answer, whether it's the sole and direct result of an line of duty injury, right? That whether the death is, would be enhanced, whether better determinations, more accurate determinations would be made if there were these trial type procedures, and specifically the ability to present witnesses and to cross-examine, for example, the medical examiner, as the board itself seems to have done in this case.
Your Honor, I think Matthews makes very clear that the type of determination at issue in this case is actually not improved at all by having those sorts of proceedings. This is a sharply focused medical determination made on the basics.
But so are workers' comp cases, and they have, hearings. Your opposing counsel mentioned trials. We have medical malpractice case. I think he said an automobile case, but it's the same point, that you have medical evidence being presented and you have differing views from medical experts. And the court normally refers to those as, quote, credibility determinations. I mean, it's really a question more, I think, about which expert does the jury, the fact finder, find the most persuasive, right? But the whole point is that there is something to be gained by the decision maker from having a full exposition of opposing views, or at least of being able to cross-examine the expert evidence that's being presented, in this case, in the form of the medical examiner.
What the Supreme Court said in Richardson v. Perales is that those aren't credibility determinations or determinations of whether the medical expert is lying. Those are professional disagreements. And the board is able to weigh those based on the written evidence before it. In fact,
Except it wasn't in this case, right? That's why they picked up the phone and talked to the medical examiner ex parte.
we believe that that was not necessary to the board's determination. And
Well, it's nice that you don't think it was necessary after the fact, but the fact of the matter is that it happened, right? The board seemed to think that it was necessary. I'm curious to know, do you think that the question of whether an injury is the sole and direct cause of death is a legal question for the board, or do you think that's just a factual medical question for an expert witness?
we believe it's a legal question for the board.
I thought you just said a minute ago that it was a clear-cut medical determination.
There was, Your Honor, but it was up to the board to apply that law to the facts presented by the medical experts in the record.
Can I ask you, I want to, for a minute at least, talk about the statutory language, but first I just want to make sure, is a logical consequence of the position that you've been taking that if the DC Council wanted to do so, it could constitutionally create a public sector workers' comp scheme where workers in the District of Columbia who, had statutory entitlements on certain showings to get benefits under the statutory scheme would be entitled only to the kind of process that Ms. ECKENRODE was entitled to by the regulations here. So no right to present live evidence, no right to cross-examine, no right to confront witnesses, it seems like it would follow from your argument that would be a constitutional system. And not only a constitutional system, just to be clear, a constitutional system, not only at the front end at making the original determination, but also thereafter, whatever record got created through that pretty truncated process, if there was like a judicial process, it would all have to be through like APA style deferential review based on whatever record was able to be created through those truncated procedures.
I think that there would be some question around the private interest prong, and if those applicants weren't receiving the same sort of sources of support that applicants here are entitled to, there might be a different weighing balance there. But there is, I do believe there is a world in which that would be constitutional. Yes.
And so back to the statutory language, for one thing, the statute seems to me like obviously incorrectly worded in one respect. I'm interested in whether you agree. So it says that the requirement is that death be the sole result of the injury, sole and direct. But I mean, obviously the injury had many results. Death was one very unfortunate one. But I mean, that can't literally be what's required. There were many, many consequences short of death that resulted from the injury. So we have to read that statute some way differently than the way it's literally worded. Would you agree with that?
That's correct. We believe it can be more clearly read as death solely resulted from and directly resulted from the performance of duty.
It's a causation.
Yes, and this court has
Injury to death.
right. This court has referred to it as a causation standard. That's the way the board has consistently applied it. And as you said, Your Honor, it would be nonsensical to apply the statute as written because many things often result from performance of duty injuries.
Well, it's almost equally nonsensical as an original matter to read it the way you're suggesting. If for the injury to be the sole cause of death in like a normal, a scientific, non-legal sense of the term, that can't be right either. I mean, the injury was one thing that happened in the world, and there's no way that it would be the only cause in the sense that nothing else was a but-for cause of death. And that's why really, it seems to me, whether something is a sole cause of another thing is a very confusing legal question. To my mind, for example, I don't think that the medical examiner's office has any particular insight into whatever that phrase might be understood to mean in this particular setting. What makes something, in your view, or in the board's view, can you explain like what makes something a sole cause of something else?
Sure. So the board defined sole as one and only. And I think taking that in kind of a combination of a legal and medical understanding, as you explained, the board has kind of drawn a distinction between complications, which are a detour from the normal course of an injury or an illness, and kind of sole causes.
So let me give you a hypothetical. Imagine that an officer is shot and is lying on the ground bleeding. And an ambulance gets there in 15 minutes and takes the officer to the hospital where the officer dies because the officer was not able to get treatment soon enough. And somebody says, a doctor says, if an ambulance had been there, it had been able to get there in 5 minutes, the officer would have survived. So it seems like death would be caused not just by the injury, but also by the relative unavailability of immediate medical assistance. Would you say in a hypothetical like that, the annuity should be denied?
No, I think that in a hypothetical like that, the understanding of kind of the sole medical cause of death would not be the kind of broader traffic patterns and access to medical care.
And how about, so I just to go down this path, show you how I find it not just, to me, it's not solely a medical question. It's actually a very difficult legal question that I'm not sure the board has shed much light on. How about if instead the officer is taken to the hospital and the officer dies on the operating table and there is evidence that there may have been pick your spectrum, a wonderful doctor could have saved the person, but this was a mediocre doctor, or in fact, it was all the way to negligence. So there was sort of a contribution to the death because medical care wasn't perfect, or in fact, might even have been substandard. Would you say no? I mean, that seems like a medical cause. And would you say no annuity in that setting?
I think that that kind of spectrum actually leads to two very different conclusions here. So if there's medical negligence or, the doctor's performance in surgery contributes to death, that would both be no longer the sole cause and no longer the direct cause of death would be the injury. There would be this intervening factor in terms of the substandard medical
And
care.
intervening, imagine that an officer is shot and an officer is taken to the hospital, is being treated, and has a heart attack while being treated. The bullet not having hit the officer's, the heart, but it was like the stress to the body of the injury and the procedures that are ongoing lead to death. Would you say no annuity because the injury was like a bullet hitting some other part of the officer's body, and then there were intervening causes, although they're all flow very, I don't want to use the word direct here, I guess, but relatively immediately and simply from the injury. There were other physical things going on that were, not, it could be viewed as indirect, depending on what you think the word direct means, and could be viewed as different from, depending on what you think the word soul means. So in a hypothetical like that, where would you say no annuity or annuity?
Sure. So the board's determination would obviously be based on much more fulsome medical records, and not being a doctor myself, I, wouldn't be able to know whether there is a kind of clear causal link between the heart attack and the bullet. But say in a situation in which a medical examiner and medical evidence suggests that the heart attack was caused by underlying complications and conditions, not.
I get that set of topics, which we haven't gotten into yet, but just so let's say deep vein thrombosis is another example. Imagine there was no evidence of any other contributing circumstance that was peculiar to the officer. And imagine that some people who get injured in the line of duty and have surgery end up getting deep vein thrombosis, and some don't. We don't really know why some do and some don't. So there's nothing particular about this officer either that would allow us to know this one did, this one didn't. But imagine that that's not necessarily this case. It may be this case, it may not be. But imagine that's true. And then imagine also that some people who get deep vein thrombosis ultimately get fatal pulmonary embolisms. And we don't really know like why some do and some don't. So sometimes happens, sometimes doesn't. There are probably other things going on that are besides the injury itself that are determining whether those subsequent events happen. Would you say in a case where there had been no evidence about relating to other conditions of the officer, would you say no annuity because the sequence of events of injury to surgery to deep vein thrombosis, which happens some but not all the time, to pulmonary embolism, fatal in character, which happens some but not all the time, that's not sole, that's not direct? Or would you say if that was what we had, that could or would be sole and direct?
I think in that case, Your Honor, it would still likely not be a sole and direct result. And that's because, as Dr. Malomo opined, DVT is a complication from these types of surgeries. As the board has explained, it does not view a complication as the direct result of performance of duty injury. Again, it's a kind of detour from the normal course.
Complications are what happens to medical patients all the time, right? They develop infections, they develop whatever, and it's a sequence of events, of unfortunate events, and sometimes they snowball. Because death is rarely, if ever, unless it's a direct, a bullet that goes in the heart and causes death immediately, death is always going to be really caused by something else. A heart attack, a bleeding out, a stroke, right? Those would be the causes of death.
That's totally correct, Your Honor. And medically, there's a difference between a complication, which is a detour from the normal kind of course of that injury.
I don't understand the detour language. And I guess, getting back to Judge McLeese's hypothetical about the heart attack, where, the officer gets shot, but then has a heart attack, right? And I thought you sort of hedged and said, well, I don't know, and I guess ultimately it sounds like you're backing away from the sole and direct language strictly applied by the board and acknowledging that doesn't make any sense, and reverting to sort of much more traditional notions of but for and proximate cause analysis, right? But that doesn't seem to be what the board did here. So that's what I'm struggling with is you seem to be acknowledging with all these hypotheticals, of course, we can't look at sole and direct in this quite literal way that the board did. We're going to have to apply these traditional principles of, is it in the but-for cause? Is it proximate enough? And then we go from there and make some sort of value judgment.
If that's what I expressed, Your Honor, then I apologize. We do believe that the sole and direct language applied by the board is the standard that would have to be applied in all of Judge McLeese's hypotheticals and any situation the board encountered. And if that leads to harsh results, then that's what's required by the statutory language that the board is bound by. The board.
Well, I guess partly, why is that required? For example, the word direct, your brief seems to suggest is like an intensifier that is a stronger requirement than proximate cause, which is a term that we sometimes use. And I found myself wondering why you believe that to be the case or what support you have for that, since a lot of our cases that say what proximate cause is will say proximate cause is a thing that is treated as the direct cause. And so I had sort of understood at least some of our cases, I'm not sure all of them are like this, but some of them seem to think that being direct is a necessary component of being proximate. Why do you think direct is an obvious sort of intensifying stringent requirement?
Sure. So in the statutory language, Congress did use the term proximate cause. So at 5716 A13 discussing intoxication, Congress did say, the causation standard here for this particular factor is proximate cause. In drafting A1A, which is the language before us here, that's sole and direct language, Congress intentionally used different words intended to mean a heightened, narrower standard.
Well, I get that about soul, although I have to say I don't quite understand how to make sense of the word soul. And of course, the words Congress chose, we are all, I think, agreed don't make sense. So we're trying to fix a statute that's fundamentally flawed anyway. But if you're right that proximate is used elsewhere and direct is used here, and some of our cases say direct is a requirement of proximate, if those things all would fit together to say that Congress intentionally used a less stringent term because they picked out only one of the components of what proximate clause requires.
I don't think that sole and direct can kind of be broken up like that.
Oh, you're saying so?
It requires that the sole and direct result be that the death of the member or officer. So.
Although again, every time you start saying sole and direct result, this is not a criticism of you by any means, because it's the words that we're given to use. But when you say sole result, my brain freezes, because there's no way that anything was a sole result. There's no way that that death was ever a sole result of an injury.
Absolutely.
So I keep, I seize up. That's my own confession, but I can't follow the rest of your sentence because I get okay, sorry, I can't. I'm stuck at go.
And I think kind of the overall point here is that the board interpreted this language to the best of its ability, relying on, as this court has directed it to, the common and ordinary use of the words sole and direct. And that interpretation of the language of the statute that it administers is entitled to some deference. There's no unreasonableness
subject to reasonability.
That's correct.
Right?
Yes.
And if it's just unreasonable because it literally doesn't make sense, then.
If this court were to find that the board's interpretation were unreasonable, it would not be.
Well, the board's
entitled to the same.
interpretation was based solely on its reference to some Oxford dictionary. Is that correct?
That's correct.
I mean, you've mentioned proximate causation and aggravation. There are other parts of the statute, but the board didn't engage in any of that kind of analysis, did it?
No, the board used again, common normal dictionary definitions of the statutory term.
Of which term?
Of sole, direct, and then it provided a kind of whole definition of sole and direct.
Because the Black's Law Dictionary has a definition of sole cause that is kind of entertaining in a way. In that what it says is a thing is a sole cause if it is what in law is treated as the only cause, which makes clear it's like a circular legal idea, which to me makes a lot of sense in that, again, if you're not in some strange way of legal speak, to say one thing solely is the sole cause of another it is hard to understand because there's the pre-existing set of the world, one thing happens and then things follow. And the thing that happened can be viewed as the cause sometimes of the things that follow. But if like everything else that's going on in the world also are understood, like in some senses as being the cause. And if you get into those, you can get into philosophy about what is a cause and what is a pre-existing condition. And you start spinning off into all of that. And I guess on the merits, it's not just, I guess, whether the board's explanation is substantively unreasonable. It's also, I guess, a requirement. Do you agree that the board's explanation of its conclusion has to be adequate?
That's correct. And just kind of before we go further into the merits, just in case this is relevant to those questions, we actually don't believe that this court does need to reach the merits, even if you find that you do have jurisdiction to hear this case. Mrs. Eckenrode has asked for a remand to the board to have the kind of fulsome trial type hearings that would be required if you found you had jurisdiction, and we would defer to that stated preference.
That she's asked for a remand so she can have the hearing type proceedings that she thinks she's entitled to, and which we would have agreed to by saying we have jurisdiction, right?
That's correct, Your Honor.
But you're saying we should not get into the question of the board's interpretation of the statutory terms because she has made that request, or even though we were to think that the board was incorrect or needed to do it over?
I believe that would be a merits question rather than a question of jurisdiction. And
It is a merits question.
Mhm.
No, I thought you were saying all we would need to do is say, we have jurisdiction, we remand the case.
If you believed that the board's interpretation of that statutory language was unreasonable, it might make sense for you to provide what you read as a reasonable interpretation of the statutory language that the board has to follow. But I understood Judge McLeese to be turning to more fulsome merits questions, and I just wanted
okay. And
to
so you
provide
think
that.
that even if we had other concerns about the board's determination beyond its interpretation of the statutory language, you don't think it would be useful for us to point them out so that on remand, maybe the board can consider them?
Obviously, that is entirely up to this court,
Yes.
but we would not oppose Mrs. Eckenrode's request to have those trial type hearings in the first instance. And, you know, to the extent that that might address some of this court's concerns, you know, that would occur in the first instance before the board as the fact finder.
Of course.
Thank you very much. We've
Thank
kept you at
you.
the podium for quite some time. We appreciate your argument.
Thank you.
Mr. Fenn, we'll give you just a few minutes.
I was gonna say, I think I have
Yep.
3 minutes on here. I'm not sure I can cover it all, but I'm gonna try to. First thing I just want to address is this statement about my client had a right to a full evidentiary hearing. That actually appears in the brief, supplemental brief filed by the board at page 4, where it says, Mrs. Eckenrode did not request an evidentiary hearing or to appear in person before the board, nor had she done so previously. My note on here in preparation for this is she had no right. Meaning there is nothing in the statutory regulatory scheme that says she has a right to an evidentiary hearing. In fact, 7 DCMR 2517 says any applicant for relief who expresses a desire to do so may personally appear before the board. No other details to what that means, but I just highlight for you that this idea that some amorphous right exists at the discretion of the board to decide, does my client have such a right or not? She never even received notice of such right until the supplemental brief was filed.
Well, just to clarify, I don't think your opponent was saying that your client had rights under any of the applicable statutory regulations. And in fact, our opinion in Farrell said otherwise. That's a number of the relevant procedural interests your client might have had. I thought the point was more your client could have asked the board to, in its generosity, provide such process and didn't. And the board, the representation is that the board typically grants such requests when they are made. I understand your further points, but I'm not sure your opponent was arguing that there was some sort of hidden right. I think instead it was more there was an opportunity. Again, may not have been adequate notice of the opportunity, but I thought their point was a little bit different that you were describing.
I would go with the words, there apparently is a hidden right. We never knew about it. We were never put on notice of it. It's not in the
In
regs, it's not in the
practice.
statute. In practice, maybe so, but my client certainly is a pro se person appealing this would never know that. I don't know how an attorney would know that unless they've been before the board before and had this discretionary right told to them before. I just point that out because I think that goes to factor 2. That factor again is the informal nature, the discretionary and the inherent risk with these board procedures that I didn't even know about until now. In addition, I want to just address the words used by counsel that the denial of the enhanced survivor benefit here was a quote, major financial, and I didn't catch her third word. I think she said impact, but she said major financial something, and I put the word impact in there. The statute designates and highlights that and highlights, as your honor pointed out, the importance and substantial nature we're talking about here of the right we're talking about. We are in fact talking about a limited class of persons, and I do want to highlight that. We're not talking about a tremendous amount of additional work being placed upon this agency whatsoever. This is a statute that clearly designates a beyond substantial level of need for any person applying for the enhanced survivor benefit, which I heard is not disputed. I also just want to address the new case that was this 472 US 305.
It's actually 473, by the way.
Thank you. That's not in the record. I have not had an opportunity to review it, but I just note, as your honor pointed out, that if it just relates to the right of counsel, I don't really know what application it has in the context we're talking about here.
Well, I think your opponent's argument is that if that case, which I've located but have not yet internalized, if that case says whatever procedural due process rights folks in that situation have, if they don't include a right to counsel, your opponent's argument is if your client also has no constitutional right to counsel, then it follows this is not a contested case because that's been an essential component of saying that something is a contested case. That's the chain of reasoning.
Understood. And I just haven't had a chance to look at it yet, similar to you. Factor number 3 that counsel did address briefly was that adding this sort of burden to the agency would lengthen the process. Your honors, we're 3 years out approximately from the death of Sergeant ECKENRODE. 3 years out. We're still fighting about this. So there's no additional lengthening of process by adding a trial type hearing. In fact, we may not be here. This may be resolved if there was a trial type hearing, and the reasoning and the need for that trial type hearing really I thought was very well highlighted by your questions about cause, sole cause and otherwise. All of those sort of intellectual curiosity sort of questions that we all have in our mind about what does this mean? What does this really mean? What happened? What was the cause, direct, sole, proximate cause, whatever the case may be. That's why you need a trial type hearing. These are the type of detailed factual inquiries that get resolved at trials or trial type hearings, because you have the ability to pull out what the facts are. You have the ability to find out what was relied upon, what was the true opinion based upon. Does the opinion have a basis upon which the board should rely? And I just point out again, the board itself, by picking up the phone, by calling the medical examiner, by doing everything it did, performed part of that function of a trial type hearing without my client involved. Now their position is my client waived their right because she knew that they were going to call. First of all, she was a pro se litigant at the time. Secondly, what I highlight to you is none of it was recorded. So there's not some sort of follow-up procedure where she could have challenged any of that, or that we even know what words were actually used by the medical examiner, because the medical examiner was never interviewed. And so the ambiguity and all the struggle I think we all have with what is sole and direct, is it proximate, what is it? All of those types of factual inquiries and legal inquiries, more factual than legal in my view, really boil down to and support what we're asking for, a trial type hearing. And to answer your honor's question, I believe you absolutely have the right to point out each and every one of the errors of the board below or things that could be improved in terms of a hearing. If you find you have jurisdiction because there is a constitutional right to a contested case or a trial type hearing, as we believe there is, you absolutely on remand can help the board in terms of its other errors that it may have had it, that we believe it did have in this process, you absolutely have that ability, and I think would be a good thing to do so.
Thank you, counsel.
Thank you very much.
Thanks to both parties for their argument today. The case will be submitted and this court stands adjourned. Thank you.
All right.